second appeal number 178. 178. 190 of 2009. अब ठीक हो गया टेम्परेचर?
हाँ एकदम ठीक है.
This appeal has been filed against the judgment dated 4/2003 with the rapid decree signed on 25/2003, passed by the 6th Additional District and Sessions Judge entitled Appeal number 1 of 1992, whereby the judgment dated 29/2/1992 within bracket decree signed on 10/3/1992, passed by the learned subordinate Judge 1 Zalibag in eviction title number 25 of 84/4 of 1985 has been sentenced. The suit for eviction on the ground of default in payment of rent and personal necessity was dismissed by the learned High Court, and on appeal it was allowed by the learned First Appellate. Consequently, the defendant is the appellant in the suit. This case has been admitted for final hearing by order dated 18/7/2006 on the following substantial questions. As per the case of the plaintiff, a double-storied house it consisted of two parts, was originally owned and possessed by Prafulya Chandra, who inducted the defendant in the southern portion of the ground floor in a portion of the building as month-to-month tenant. The area put under tenancy has been described in Schedule A of the Act. The specific case of the plaintiff was that defendant paid the rent to Prafulya Chandra as long as he was alive, and he would grant rent receipt to the defendant in token of acknowledgement of rent, and the defendant used to sign the and he died sometimes in the month of January 1975, leaving behind a son named Deepak Mitra and two daughters and widow. Two daughters namely Chandra Basu and Ratna Bhatra, and his widow namely Ida Mitra, who jointly inherited the property. It was further case that the defendant started making payment of monthly rent to Deepak Mitra against grant of rent receipt and paid up to the month of July 1975. And since the month of August 1975, the defendant started remitting rent by money order. It was always received by Deepak Mitra up to the month of February 1984. And the rent for the March of 1984 was returned to the defendant. And it was alleged that the return was the producer. It was further case of the plaintiff that they purchased southern half portion of the double-storied building including the tenanted premises described in Schedule A by virtue of registered sale deed dated 6/4/1984 for a consideration of ₹32,000 and became the absolute owner of the same. It was the further case that the vendor of the plaintiff, Deepak Mitra, and also the defendant and other tenants, orally and also in writing, informed the defendant and also sent a registered letter dated 26/4/1984 and requested him to make payment with respect of the rent to the plaintiff from the date of the sale deed. The purchaser of the suit property are the plaintiff's reports. The defendant, in turn, responded that Deepak Mitra and his mother, Ida Mitra, on receipt of earnest money of ₹5,000, had executed an agreement of sale of the southern portion of the holding for total consideration amount of ₹30,000 on 6/10/1983. And since the date of the agreement, the defendant was in possession of the suit premises as owner. It was asserted by the plaintiffs that Deepak Mitra and Srimati Ida Mitra never executed any agreement of sale in favor of the defendant, nor received any amount as earnest money. And the agreement was a forged and fabricated document. It was also asserted that the other tenant, on receipt of the personal necessity, was also raised in the plaint. The plaintiff accordingly raised a ground for eviction that the defendant was liable to be evicted on ground of default in payment of rent and was a defaulter for more than 2 months, and in spite of request, the rent was not paid. The defendant filed a written statement opposing the claim and asserting that the suit itself was not maintainable and the suit was filed to counter the effects of the defendant's suit seeking specific performance of contract with respect to the agreement entered into between the defendant and the original owner of the property. The it was also asserted that Deepak Mitra and his mother had cheated the defendant by their illegal action by registering the sale deed in favor of the plaintiffs. It was asserted that the agreement of sale was executed by them in favor of the defendant on 6/10/1983, and in part performance of the contract, they received rupees 5,000 from the defendant, and the balance amount of rupees 25,000 was to be paid at the time of execution of the sale deed. And they asserted that they were in part possession of the property. They were already in possession of the property since 1953. It was also asserted that the purchase by the plaintiffs was made with the knowledge of the agreement, and therefore the plaintiffs did not require any title over the property. The specific case of the defendant was that the plaintiffs did not become the owner of the property, and so they were not entitled to receive rent, and adequate reply was given to the plaintiffs. It was asserted that the question of payment of rent to the plaintiffs, agent or anybody, did not arise. and there was no relationship of landlord and tenant between the plaintiffs and the defendant. The landlord and tenant relationship between the vendor of the defendant, between the vendor of the defendant and the defendant ceased from the date of the agreement, that is 6/10/1983, and a new contract came into existence, which was being enforced by the defendant, who was the prospective owner of the, who was a prospective owner in possession of the suit property. A plea was also raised that the suit for enforcement of the specific performance of agreement dated 6/10/1983 the suit for specific performance of the contract was pending at the time of filing of the suit. No?
Yes.
It was pending at the time of filing of the suit. The learned trial court framed the following issues for consideration. There are three missing. By considering the issue number 4 as to whether there was a relationship of landlord and tenant, the learned court considered the materials, including the agreement of sale, and also the fact that the money order was lastly sent to Deepak Kumar Mitra for the month of March 1984, which he refused to accept. The learned court ultimately recorded a finding that on the basis of the agreement dated 6/10/1983, the title suit number 56 of 1984 was already decreed, and therefore the relationship of landlord and tenant between the original owner, there was no relationship of landlord and tenant between the parties. It was also held by deciding the issue number 5 and 6. it was held that even if it is assumed that there was default in payment of rent and there was personal necessity, but the agreement dated 6/10/1983 has been found to be valid and binding, and therefore no decree of eviction could be passed by treating the plaintiff as the landlord with respect to the suit. The trial court ultimately dismissed the suit. Before the learned first appellate court, the plaintiffs raised the following points. Paragraph 2. The learned first appellate court framed the point for consideration in paragraph 5 as to whether the judgment and decree passed by the learned court was in accordance. It is important to note that the suit for specific performance of contract, which was decided in favor of the plaintiff of the state case, who is a defendant in the present case, was passed on (29/2/1992), and the said judgment was set aside by judgment dated 4/3/2003 and is subject matter of Secretary number 178 of 2003. The first appellate court in the present case recorded that the result of title appeal number 8 of 1992 arising out of title suit number 56 of 1994 shall automatically affect the result of the present appeal of the first appeal involved in the present case. The learned court ultimately recorded that the learned first appellate court ultimately recorded that the learned trial court came to a wrong conclusion and against law, that only because the deed of agreement of sale dated 6/10/1993 was found to be valid the eviction suit shall fail. The learned first appellate court further recorded that the trial court did not, the learned trial court appears to have fully ignored the importance of legal aspect of the matter, that when the defendant of the present suit did not perform the part of the contract by depositing the remaining portion of the amount within the stipulated period of 6 months as required under the agreement dated 6/10/1983, the defendant of the present eviction suit was not entitled to get the sale deed executed in his favor by the vendors of the suit premises. The learned court thereafter recorded that the learned trial court has not discussed about the subsequent purchase of the suit premises by the plaintiffs on 6/4/1984 and arrived at wrong and erroneous conclusion, and also observed that the learned trial court appears to have completely ignored the ground of eviction taken by the plaintiff in the present eviction suit. The learned court also took into consideration that the judgment passed by the learned first appellate court in the present case is well influenced by the other judgment passed relating to the specific performance of contract arising out of title suit number 56 of 1984, whereby the learned first appellate court in the same case found that the judgment in the title suit number 56 of 1984 was not in accordance with law, and a separate judgment has been passed. The learned first appellate court observed that the finding of the appeal arising out of the suit specific performance of contract, whereby the decree of specific performance of contract was set aside, shall automatically affect the appeal and the judgment of the trial court cannot be sustained. The learned court further recorded in paragraph 11 of the given judgment that the plaintiff's vendor was admittedly receiving the rent from the defendant, and therefore there was a relationship of landlord and tenant between the plaintiff's vendor and the defendant, and further recorded that from the evidence the court did not find anything to hold for partial eviction. Last sentence. The learned first appellate court ultimately held that the plaintiffs were entitled for a degree of eviction and consequently allowed the appeal, and the judgment of the trial court refusing proceeding to evict the defendant has been set aside, and 1 month's time was granted to the defendant to vacate the premises. This appeal was admitted by this court. ये तो हो गया ना? Following substantiation. Okay. The learned counsel for the appellant, while referring to the substantial question of law, has submitted that the appellants were the prospective purchasers of the suit property by virtue of the agreement of sale, and therefore the relationship of landlord and tenant and therefore it could not be said that there was a relationship of landlord and tenant between the plaintiffs and the respondents. The plaintiffs were the purchaser of the suit property after the agreement of sale was entered into between the vendors of the plaintiff and the defendant of the present case. The learned counsel has submitted that the learned court, the learned first appellate court, has travelled beyond the scope of the suit inasmuch as the suit was to be decided on the basis of the suit was to be decided with respect to the relationship of landlord and tenant, and the question of title was totally out of the scope of the suit. The learned counsel submits that the pursuant to the agreement dated Six 1083, the defendant did not pay the rent to the vendor of the plaintiff, as the defendant had become the owner of the suit property, and as per the agreement itself, the defendant was not required to pay the rent after the agreement of sale. It submits that once there was an agreement that the defendant was not supposed to pay the rent, after entering into agreement of sale, the relationship of landlord and tenant ceased, and therefore the purchaser of the property, who was the plaintiff in the present case, could not assert relationship of landlord and tenant between the parties. It means that there was no occasion for the defendant to tender any rent to the plaintiffs, and the defendant has never tendered rent to the plaintiffs. The learned counsel has also submitted that since the defendant had entered into an agreement of sale with the original owner of the suit premises and continued in possession of the suit premises, but not as a tenant, but as a owner of the premises. Therefore, the relationship of landlord and tenant ceased, and the defendant was in part performance of the contract of sale as a prospective purchaser. The Learned Counsel submits that the Learned Counsel has referred to section 53 capital A of Transfer of Property Act and has submitted that the possession of the defendant in part performance of agreement of sale was duly protected. The Learned Counsel has also relied upon the judgment, Tiwari wala Rajendra Tiwari, na? Judgment passed by the Honorable Supreme Court, reported in bracket 2009, bracket close 9, bracket 2000, bracket close 9, SCC 339. And has submitted that in a case dealing with food for eviction, there is no scope for entering into title dispute. The Learned Counsel has also relied upon the judgment reported in bracket 2022 bracket close 10 SCC 496.
Rajendra Tiwari, they have referred for a relationship. 2000 volume 9 SCC was P. Kantimati, in which they say कि agreement हो गया तो relationship landlord tenant का नहीं है. This 2022 has distinguished P. Kantimati.
Has relied upon the judgment reported in bracket 2000 bracket close 9 SCC 339 bracket R. Kantimati versus Beatrix Xavier to submit that once an agreement of sale is entered into between the tenant and the original landlord, the relationship between the parties of that of landlord and tenant ceases to exist. That's all. He submits that both the substantial question of law be answered in favor of the appellant and against the respondents. The Learned Counsel for the respondents, on the other hand, by opposing the pair, has submitted that the Learned First Appellate Court has considered every aspect of the matter by coming to a finding that there was a relationship of landlord and tenant between the parties. He submits that since he submits that it is further not in dispute that the plaintiffs of the present case had requested the defendant to tender rent pursuant to their purchase by way of registered deed, but the defendant refused to tender rent to the plaintiff, and therefore the default in payment of rent is not in dispute. The counsel has also submitted that atonement of tenancy is not required, correct?
Actually, come here. about, because they filed suit for specific performance prior, but the date is just two dates. 21/5/84 is the date of specific performance suit, and eviction suit is 31/8/84. That is after 3 months.
The learned counsel submits that the suit for specific performance of contract was filed on 21/5/84, and the suit for eviction was filed on 31/8/98.
But they were aware that there is a state date because they have challenged my state date.
Yes. He submits that there is no dispute that the defendant were fully aware about the state date, but in spite of request and in spite of knowledge, they did not tender any lend to the plaintiff, and atonement is not necessary so far as the landlord-tenant relationship with respect to the subsequent purchaser of the suit premises is concerned. The learned counsel has also submitted that the date of agreement is 31/10/1983, 6/10/1983, and it is admitted from the records of this case that the defendants had tendered rent till March 1984 through money order, and so far as the rent of March 1984 is concerned, the same was refused to be accepted by the original owner of the property. The learned counsel submits that there is no explanation as to why the learned counsel submits that merely because there is an agreement of sale, the same does not confer title upon the defendant, and in the case arising out of BPC Act, what is required to be seen is only the relationship of landlord and tenant, and certainly, and in view of the fact that the defendant continues